Alen-Shenker. This with the Department of Law and Business at the Pitt Rogers School of Management at Ryerson University, all the way out in Canada.
Yep.
And she's here now, all the way from Canada. Teaches labor law, employment, like law, hospitality, and tourism.
Yes.
We'll have a conference on that.
Okay. Thank you, everybody, and good afternoon. The paper that I'm going to talk about today is about mandatory retirement, a phrase that was we talked about mandatory retirement. We just mentioned it yesterday a bit and today. So first of all, mandatory retirement is a workplace practice according to which employment relationship terminates at a fixed age. The employer can just dismiss an employee at a fixed age, let's say 65, solely on the basis of his or her age. And it's often not officially legislated. There are some unique cases, such as the case of Israel, but usually it's widely exercised through workplace practices, policies, contracts, or collective agreements, or conditions on pension plans. And just to give you an overview of the paper, I will start with the global trend. In recent years, we saw that more and more countries, because of the impacts of the aging population, decided to abolish mandatory retirement practice. However, each jurisdiction allows for a large range of exceptions, and it's often engaged in vigorous debate on the interpretation of those exceptions and their scope. And as more and more countries introduce new legislation against age discrimination, the debate on whether to abolish mandatory retirement or not hits up. So the paper argues that the central question is actually not whether we should abolish mandatory retirement or not, but rather, once abolished, what are the circumstances in which mandatory retirement should be allowed. And this is a legal paper, so no quantitative research. Is a qualitative research only, and the paper takes into account the unique characteristics of age as a prohibited ground of discrimination and offers a theoretical framework established on substantive principles of equality for balancing the different rights and interests involved, the rights of a senior worker against the rights of younger workers, employers, and society as a whole. And based on this theoretical framework and act of balancing, the paper advocates a narrower interpretation of the exceptions to the prohibition on mandatory retirement and outlines the specific circumstances in which mandatory retirement should be allowed. So the paper starts with a description of the global trends towards the abolition of mandatory retirement and highlights the great variety of legislative arrangement in different countries, including the United States, Australia, New Zealand, Canada, and the UK. In the US, for example, mandatory retirement was abolished in 1986 when the Age Discrimination in Employment Act was amended, and age discrimination was in employment against workers aged 40 and above was prohibited. There's a major exception to this prohibition. It's the bona fide occupational qualification that says that the employer has to show that the essence of the business operation would be undermined if employment decision is not based on age, and that all or substantially all workers above the age qualification are unable to perform safely and effectively the job duties, or it's impossible or highly impractical to deal with senior workers on individualized basis, and generalized policy is more acceptable. So this is a very narrow exception applicable in rare cases such as pilots or firefighters, and so on. In Canada, Quebec and Manitoba were the first provinces to abolish mandatory retirement in 1982 and 83. In recent years, more and more, almost all provinces have abolished mandatory retirement. However, some Canadian provinces have left more room for exceptions, and others were more left less exceptions and almost abolished this practice entirely. For example, in some provinces such as Ontario and BC, mandatory retirement is now unlawful except in limited circumstances, such as when age is a bona fide occupational requirement. Similarly to the American exception, the age requirement, the employer has to show that the age requirement was adopted for purposes rationally connected to the performance of the job in good faith, and that the age requirement is reasonably necessary to accomplish the legitimate work-related purpose. And in order to prove that, the employer has to show that he or she has tried to accommodate the worker unsuccessfully up to a point of undue hardship, and there's no other choice but to have age discrimination or mandatory retirement. So it's a narrow exception. Other provinces, such as Newfoundland or Saskatchewan, mandatory retirement is generally not allowed, but they allow for a large range of exceptions, broad exceptions. One example is the bona fide retirement or pension plan. According to this exception, according to this exception, this exception permits pension plans to provide benefits only after an employee reached a certain age, thus allowing de facto mandatory retirement. Now, according to the Supreme Court of Canada, this exception applies as long as the pension plan is not a sham, which means that the employer only has to show that the plan in itself is bona fide. It doesn't have to show that mandatory retirement age provision in this plan is necessary to the operation and sustainability of the plan. So it's a broad exception to be used by those provinces and employers. Moving to Europe, the EU adopted, yes. So what do you don't understand? Sorry. What?
If somebody wants to stay on.
Yeah. So why do they have it as part of their pension?
If he stays on, it is better for the pension fund.
Yes, but these are pension plans by the employer.
Yes.
And the employer wants to get rid of those people because they don't want to pay them more and more increased salaries. So they want to have a termination date for the deferred compensation model contract. So they want them to be out. I agree with you that employers should also think about the fact that they need to pay pension and try to delay retirement, but this is what's going on with those plans. Okay? So moving to Europe, the EU adopted in 2000 a directive which prohibits direct and indirect forms of discrimination in employment on the basis of various grounds, including age. Again, it allows for a wide range of exceptions. And, for example, the Article 4 permits differential treatment when the prohibited ground constitutes a genuine occupational requirement, the GOR, similarly to the American and the Canadian BFOQ and BFOR. But there's another exception, a broader one, Article 6, that exempts the use of age-based distinctions if the use is objectively necessary to achieve a legitimate aim and proportionate to the aim sought. This is a broad exception, which means that you can have mandatory retirement even if if you have an aim that is legitimate. It doesn't have to be a work-related issue. It could be employment policy, labor market policy, or vocational training objectives. So more general objectives to justify mandatory retirement. Now, the directive does not require member states to outlaw mandatory retirement. Yet, if an employer or if mandatory retirement is based on a contract or a collective agreement or a policy, the employer has to justify this arrangement using Article 4 or Article 6. The courts in Europe have given a broad interpretation of this article. Just to give you an example, the European Court of Justice held that a Spanish law permitting mandatory retirement in collective agreements was justified under Article 6 because it was designed for a legitimate aim. And what was this aim? To create vacancies at a time of high unemployment and to promote intergenerational employment with cooperation of trade unions and employers' organizations. Now, many member states have recently introduced legislation against age discrimination in response to this EU directive. But the practice of mandatory retirement is still widely exercised. Only few decided to abolish mandatory retirement, and one recent example is the UK. Yes?
I frankly don't understand because I know that there are some very few countries that have mandatory retirement.
Only in collective agreements in Europe.
In Europe?
Yeah. What I said at the beginning is that usually it is not officially legislated. There's no primary legislation that says mandatory retirement like we have in Israel. What we have in Europe is collective agreements that permits that. That once if you want to get your pension, you have to retire.
Yes, but...
Let's save it for the end, okay?
Okay.
Can't pick you up on without the microphone anyway.
Yeah, okay. So, now, so in the UK, the UK introduced in 2006 employment regulation employment equality age regulation in 2006 to end age discrimination. They have the same exceptions as the EU directive, which includes the GOR and the proportionate means of achieving a legitimate aim. Now, until recently, there was a national default retirement age that applied in the UK, and employers could dismiss workers who reached the age of 65 solely on the basis of their age. Now, this clause was not conditioned on pension qualification or any agreement between the parties. However, as of October 2011, the default retirement will be abolished. Exceptions are still apply, so still employers can have mandatory retirement arrangement if they can justify them based on the GOR or to say that this is mandatory retirement arrangement in my workplace is a proportionate means of achieving a legitimate aim. Now, the paper then moves to discuss the primary arguments for and against mandatory retirement, and I'm going to talk about that just briefly to mention that some of the arguments are based on rival factual claims. Proponents of mandatory retirement say that there's a statistical decline in productivity and job performance associated with aging, and if mandatory retirement is banned, it would require costly systems to monitor performance and cause a decline in firm productivity. In contrast, opponents of mandatory retirement argue that there's no compelling empirical evidence to support the claim that job performance or productivity declines with age, and even if there's some decline, it could be offset by other traits such as knowledge and experience. Some declines can be easily and inexpensively be dealt with through accommodation, and therefore age is a poor proxy of job performance. But most of the arguments are normative in the sense that they involve a tacit act of balancing the interests of senior workers against the interests of other workers, younger workers, employers, and society as a whole. For example, the argument that by obliging workers to vacate their place when they reach 65, mandatory retirement provides job and promotion opportunities for new and younger workers. Or another example, the argument that mandatory retirement facilitates a deferred compensation model of long-term employment relationship where wage increase throughout the years and employers would like to put an end, a termination date for that, and that this arrangement is beneficial for both sides because it promotes loyalty and commitment and an exit from the labor market that is dignified. You get a pension. It's a generous one. There's certainty. You don't need to use performance evaluation and monitoring for that, and it reduces unwanted turnover. So as we can see, there are wide spectrum of opinions and arrangements with regards to mandatory retirement in different countries. Now, an absolute denial of any form of mandatory retirement often arouses enormous antagonism because it also denies arrangements that both parties, usually unions and employers, pushed for and which are mutually beneficial to workers and to employers. But at the same time, protecting the rights of senior workers is essential. So it seems right to allow mandatory retirement in some circumstances. The question is how to determine those circumstances. This, I argue, requires a richer theoretical account of the rights and interests involved. And so if some of the arguments are factual, I say most of them, or the crux of the matter, is normative. We need to answer this question, or to say the question critically depends on our conception of the right to wage equality. Is there a right to wage equality? How important is that? What is our normative view of which interest of senior workers ought to be protected, and how this interest of senior workers should be balanced against the interest of other workers, employers, and society as a whole. So we need to find out what is the meaning of age discrimination. What are the wrongs associated with age discrimination? Is mandatory retirement, is age discrimination, amounts to age discrimination, and what should we do about that? So in another paper, I argue that the relative weight that is currently assigned to the right to age equality is inappropriate. And the paper critiques a prevailing conception of equality assessment known as the complete lives approach to equality assessment, and argues that this approach prevented the development of a robust theory of age discrimination. Since this approach has many difficulties, the paper develops an alternative approach, the Dignified Lives approach. And here in this paper, I argue that we can use this approach, this new framework, to outline the circumstances in which mandatory retirement should be allowed. So a bit about this approach. So starting with the complete lives approach, this is a philosophical view shared by many egalitarian moral theorists, that equality should be assessed according to a complete lives perspective. Since we all age, we get the same benefits and bear the same burdens at different stages of our life. Since burdens at one point of time are compensated for benefits at another time, when we measure inequality, we need to add up the benefits and burdens in each life and compare the sum. When the complete lives of two individuals contain equal total shares of resources, they are treated equally. As you can see in this example, this complete lives approach says, we don't look at time 3 and say, oh, there's an age discrimination here. Person A is getting 1, person B is getting 5. It could be well-being or resources or whatever. We have to look at their entire life. And the complete lives approach has significant implication for age discrimination discourse and analysis. First, it infers that since inequality between age groups represents inequality at a particular time between people of different ages, age distinctions is not significant. Furthermore, it allows and even justified age distinctions as long as from a full life perspective, the young and the senior receives benefits and bear burdens equally. It also promoted the fair innings argument, according to which senior people have had their fair shares of resources and should now vacate their place and make room for younger people. Accordingly, it has been widely argued that mandatory retirement is not unjust age discrimination. Several judges in Israel and other courts says if everybody has to retire at the age of 65, then there's no age discrimination here. They will all reach this age, will have to retire, no age discrimination at all. However, the complete lives approach suffers from several difficulties. Mainly, this approach does not oppose even the most severe disparity between the young and the senior, insofar as the sum of their benefits and burdens over the year is even, which means I can even say a 0 at time 3, and that's okay. Let's not give them anything at one time, because when we sum up everything, they get the same. So it even justified a severe disparity at later stages of life. Furthermore, many conclusions drawn from the complete lives approach, such as that mandatory retirement is justified or not unjust, are often based on the presumption that employment is a scarce resource. However, labor markets are flexible and dynamic and may create as many jobs as there are workers. The labor market is not comprised of a fixed numbers of jobs that can be collected from a senior worker and reallocated to younger workers. This was widely rejected in the economic literature and is known as the lamp of labor fallacy. So I therefore offer an alternative approach to equality assessment that I named the Dignified Lives approach to equality assessment, which comprises two major components. First, it considers all human beings. 2 minutes? How? Because of? No, it can't be. Okay, so I'll try to do it quickly. It considers all human beings as of equal moral worth. Every individual is treated with equal concern and respect at any given time, not just at the end of their life. Equality is not assessed through a comparison between two individuals, but rather through a set of 5 principles stemming from the notion of equal concern and respect. What I did is I looked at the legal literature and a philosophical literature that talks about what is equality, and not in comparative concept, but what is equality, what are we trying to promote. And I articulated 5 principles, 5 substantive principles of equality. Equality is about individual assessment. It's about providing equal influence, non-oppression. It's about providing minimum conditions of living, sufficiency. It's about including more and more people in our society, not against exclusion, and it's about providing individuals with free choice and autonomy. I'm sorry that I can't talk more about that. So the other paper says not every age distinction is unjust. It is unjust when one of those principles is breached. When you have an unequal treatment that is based on stereotype or prejudice, which breach the first principle of individual assessment, or when you have an unequal treatment that perpetuates oppression or denies access to minimum condition of living, this is unjust age discrimination. Now, to go back to this paper and to apply that and to see whether we need to have mandatory retirement or in what circumstances, I said that a general rule, a policy or a law like we have in Israel that allows mandatory retirement to all workers with no other conditions attached should be struck down because it violates the 5 principles of equality. First, it's usually based on ageist stereotype, productivity declines, and it doesn't take the person the individual, doesn't allow for individual assessments. It just says, okay, everybody has to retire. We don't look at whether you want to continue working, whether you're capable of continue working. It also perpetuates oppression of senior workers. It just uses senior workers as means rather than an end. It says, okay, we need to deal with pension deficits. Okay, so let's increase the age of eligibility to pension plan to 65. At the same time, it says, okay, but we need to take care of younger workers, So let's tell all senior workers you have to retire at 67, or at least employers can fire you at 67 and you can do nothing about that. Now you can try to find another job, but even if you find it, the National Labor Court of Israel said equal opportunity legislation doesn't apply to you. So if you are discriminated against on the basis of your age, you find a job when you're 67, it doesn't apply to you. You can't sue. So it uses senior workers. It also denies them minimum conditions of living. Until recently, many workers didn't have pension. Now we have the extension order, but we still, it's modest contribution, not necessarily enforced by employers. There are employers that will tell the workers you have to retire at the age of 67, but at the same time do not contribute to So as I mentioned, all those 5 principles are breached. But 1 minute, okay? But I think we should allow some mandatory retirement arrangements if you can mitigate the damage or the problems within each of those principles. For example, there could be an independent commission that will approve ex-ante mandatory retirement arrangement, and they can look and see whether this arrangement is beneficial, balance the interests of senior workers and other people in an adequate way. In conclusion, I think we should have 2 exceptions to the prohibition on mandatory retirement. So we should abolish mandatory retirement, and we should have 2 exceptions. One should be a limited exception that says, okay, if you have unique characteristic of the job and people have to retire at a certain age, for example, for pilots, then you can have it. The second one, mandatory retirement should be allowed if it's a proportionate means of achieving a legitimate goal, similar to the British exception. However, I don't think that the interpretation should be broad as the British or the European interpretation, where you just say, okay, we need to deal with unemployment, so we need to have mandatory retirement. No, you need to show more specific information, more specific evidence, maybe at the micro level, that you have a problem with unemployment or with younger workers that are not promoted, and this is the only way to achieve that. Thank you.
Thank you.